Mr. Chairman, my name is Bryn O'Brien and I represent the Australasian Centre for Corporate Responsibility, ACCR, and the 121 other shareholders who have filed these resolutions. I myself am also a shareholder. ACCR is an organisation that favours policies and risk management approaches that preserve the long-term interests of shareholders. We are particularly concerned to ensure that companies fulfil the commitments that they have made to shareholders and to society, and that they have adequate processes in place to identify and to respond proactively to emerging social and environmental risk. The first resolution we have put today, Resolution 5.1, seeks an amendment, as you say, to our company's constitution in order to strengthen these processes through facilitating the valid filing of advisory resolutions. Our company would benefit from such a mechanism, and I commend it to fellow shareholders. Turning to Resolution 5.2, which requests information about our company's risk management processes and the fulfilment of our company's commitments, which it has voluntarily undertaken under the United Nations Guiding Principles on Business and Human Rights. It does not ask for anything that would, in any way, undermine Australian judicial processes. By the way, those processes, as they relate to refugees, have been found by numerous international authorities to be seriously deficient. The international framework calls clearly for companies to refuse participation in government activities that violate human rights. And Mr. Chairman, I listened to your views about the role of government, but this is just not a tenable position under the UN Guiding Principles, and it's simply incorrect. And I point you to the expert statement signed by the likes of former Human Rights Commissioner, Professor Gillian Triggs, well-known businesswoman Janet Holmes-A-Court, and numerous academic, business and investment professionals, which speaks to this issue, and I note your reaction to the mention of Professor Gillian Triggs. We have very real concerns that our company is either ignoring or fails to understand its human rights commitments in this specific context, and this context only. That it is so used to providing services to the Australian government that it has unwittingly waded into very dangerous territory indeed. Dangerous for our brand, as Mr. Sampson will well note, which is premised upon standing up for what is right. And it is also dangerous to vulnerable men, women and children. In addition, however, to the human rights risks, we understand that moves within the global trade union movement to oppose commercial airline involvement in forced deportations are imminent. The International Transport Federation, a trade union of almost 700 transport unions globally, is about to release a statement calling on commercial airlines to refuse to take part in forced deportations. They are concerned about the impact that deportations have on frontline staff, the dangers to both staff and passengers from disruptive activity on flights, and the evidence of trauma suffered by workers who have witnessed forced deportations. Mr. Chairman, I engage in my daily job with the largest companies on the ASX. In order to manage risk, asking hard questions is sometimes necessary. What concerns me with this company, more than any other company I have engaged with, is this company's refusal to think seriously and deeply about the issues we have raised. Our company has misjudged this, has misread the winds of community sentiment and the risk profile of these activities. There is, however, still an opportunity for our company to improve before the danger gets out of hand, and we strongly encourage our company to take it. Implementing a robust due diligence process for government contracts is the first step in doing so, and disclosing this process to shareholders is in shareholders' interests. I commend this resolution to shareholders. This is to say, if this risk persists for our company and our company does not move to put basic processes in place, as requested by the resolution, we will likely proceed with a further program of engagement next year. So hello, Mr. Goyder. In some of the proxy advice, there is a curious sentiment expressed by the investment community that advisors feel that our company responding to the request we have made may in fact increase risk to the company and its business interests, So my question, Mr. Chairman, is this. Do you believe that were Qantas to implement the due diligence review and reporting process requested in this resolution, there is a danger that it would damage Qantas' business interests with government?
Can I say, I understand completely the points you make, and you raise a number of issues there as you went through your statement regarding ignoring or failing to understand the circumstances of this. I refer you back to our statement, or the statement I read earlier, that we are not in a position to second guess. We transport people, some of whom might be refugees, some of whom might be criminals. We don't know the details, and we are certainly not in a position to assess independently from the courts as to the appropriateness of the action we take. I understand you feel very strongly, and I expect others feel very strongly about this.
This isn't about feelings, Mr. Chairman. This is about risk.
It might be about risk, and we're very conscious of risk. And if we feel at any time that our employees or people travelling on our planes, customers, are in danger or at risk, we will assess that risk, and we always do. But I think the important thing here is that we are not trying to second guess the judicial processes in Australia. I understand the concern, and I've heard many times it expressed by people like Professor Triggs and others, but the situation is, as I described earlier in our statement. I don't think I can add much more to it than that.
So I guess what you're saying, Mr. Chairman, is that Qantas has made a commitment, and that commitment is to the UN Guiding Principles on Business and Human Rights. Now, that document is very clear. That document calls on companies to refuse participation in government activities that are abusive. So is this an exception to your commitment under that document?
We comply with the laws of Australia, and we will continue to comply with the laws of Australia. If the laws change, we will comply with those. I think I've given it a fair go, but are there others?
In that other, in response to my last question.
Just 1 minute. I've given you a fair go. Others may wish to ask some questions, and if I can, I'll come back to you then. Are there any other questions on this topic? Number one.
Chairman, may I introduce Ms. Brahmi Jenkins?
Mr. Chair, I did hear your opening statement to Resolution 5.2 and your comments just now about Australian law. However, there is extensive and authoritative evidence that due to recent changes, Australia's laws and procedures for identifying refugees and ensuring they are not sent to harm are not compliant with human rights obligations. With this knowledge, how can our company take a progressive position on modern slavery and marriage equality and yet continue to facilitate the involuntary deportation of children, women and men seeking asylum?
That's a pretty broad question. Certainly in relation to marriage equality and issues of inclusion, etc., we're very conscious of giving everyone an opportunity and being inclusive. As regards this issue of transportation of refugees, I can't add a lot more to what I've said before, that we comply with the law. If the laws change, we will comply with those, but we comply with Australian laws, and we don't try to second guess judicial decisions. If somebody disagrees with those decisions, they have rights of appeal through the judicial process, not to try and have Qantas overrule them. There was another question up here, number 3.
Chairman, may I introduce Ms. Watkins?
Thank you, Chairman. As I said earlier, my work involves advocating for people seeking asylum in Australia in the Federal Circuit Court. I just wish to correct something, a misunderstanding perhaps that you are under, and perhaps the board is as well. If Qantas is relying on judicial processes to ensure due diligence in relation to asylum seekers, unfortunately the legislation enacted by the Australian Government, the Migration Act, doesn't allow appeals for people seeking protection through protection visas. The court's hands are tied in this regard. Appeals are not allowed. The applicants may go for judicial review, but that's very rigidly restrained to jurisdictional error, whether someone did something it was supposed to do or not. There's no appeal available for someone seeking protection in Australia. now I'll go on to my statement, if you allow me. As I said, I see firsthand the trauma inflicted on this vulnerable group of people and believe there is reputational harm in our company continuing to be complicit in their inhumane and unlawful treatment by the Australian government. I understand from statements made by our company that the company does not differentiate between people seeking asylums and criminals. Is that correct?
Well, we are told, as I understand it, I'm a little more familiar with the details of this, we are told that people are being transported, and we're not told the circumstances of those individuals. Helen, can you elaborate on that?
In our dialogue on this one, I mean, this is very clear. There's a lot of different reasons that the government has for us to transport people. In some cases, there are people in custody, there are people that have committed crimes that have to be removed from the country, there are people, asylum seekers that are being moved for medical reasons, and there are asylum seekers that are judged not to be, that are being moved for other reasons. And so there's a variety of different reasons the government asks us to carry people. We don't know all the details of each individual case. And the problem with this resolution, it would mean that we would have to make a judgment call with information we don't have about what is the merits of each individual case. That's really not for the airlines to do. That is really for us to, and if it is about changing the law and changing the government policy and about allowing the judiciary to have more say, that's a completely different argument than asking the airlines to implement a procedure and determination with information that we don't have. And when it comes to the issues around risk, we do have a position where all passengers or pilots or security people make an assessment all the time on all the passengers that are carried on the business, and they make a judgment about the risk to operation that can take place. And we do at times not carry people if we believe that is causing a risk to the operation of the business, and those risk assessments are continually done in this business, and nothing in this case changes that.
Mr. Chairman, do you acknowledge that the refoulement of people seeking asylum falls foul of every international law on the subject, and are you comfortable with that?
I beg your pardon, could you just repeat?
Sending people back to countries where they will fear harm.
Well,
Refoulement.
I'd have to say there are differing views on how asylum seekers or potential asylum seekers should be treated, and that's a matter outside the scope of Qantas transporting people. As I said before, we comply with the law, and you made the point about appeals. We don't decide whether something can be appealed. All we're saying is we comply with the laws that are applicable, and we should not be in a position to overrule or be a court of appeal beyond that. The lady here in the red wanted to ask you some other question. I'll give you another go.
I'd just like to finish what I'm saying, thank you. I appeal to all the shareholders
question,
here,
if you
in
would
particular Mr. Oric of the Shareholders Association, to please make the most of this opportunity to make Qantas a better and more responsible company and vote for the resolution on human rights. Thank you.
Thank you. The lady in red, I think, wanted to ask another question.
Chairman, may I introduce again Ms Watkins?
O'Brien.
Sorry,
She
it's
was.
okay.
O'Brien.
Ms O'Brien.
So to return to the question I asked at the end of my statement, do you believe that were Qantas to implement the due diligence process requested in the resolution, that there is a danger that would damage Qantas's business interests with government? So if Qantas were to undertake the due diligence review and were to report to shareholders as requested, do you believe that it would damage Qantas' relationship with government?
Look, I think the important thing here, we don't have the facts available to us in every situation.
You could ask.
We don't have the facts. They're confidential information, and we don't have the facts, and I'd have to say the circumstances are such that we're advised by the government. If we were to ask, I wouldn't be surprised if the government said it's none of your business.
And has government, so there's an interesting question here, because what you're saying is that you've entered into contracts where your ability to conduct due diligence is restricted. And I say to my fellow shareholders, that is a big red flag. That is a problem. If a company cannot conduct appropriate due diligence. That is a real cause for concern. And I would ask the question again, do you believe that there is a risk in asking for this information?
I'm
in
not sure there's
reporting
a
to it?
risk. I'm just saying that we won't necessarily get some of the information because it's personal and confidential. Alan, do you want to make a comment?
I just think it's impractical completely, and I think the reality is that Qantas carries 56 million people a year. We have to make a judgment on everybody that's being carried, whether somebody poses a risk to the operation when they get on an aircraft. We do that all the time. We have to take people off aircraft if we don't believe it's appropriate. We make it on the information that we have available. What you're asking us to do in this case is make a determination on information we don't have, on information we will not get, and information that makes it impossible for us to make a judgment call on this one. And that's just not feasible. So it's irrespective of the reaction to the government, what's being asked here is something that we just can't do. And I believe in conversations with your organisation, there is a belief that in some circumstances it is appropriate for medical reasons and other reasons to actually transport asylum seekers. And it is in some cases, we have an extradition treaties between the various states where we move people around the country, and it is appropriate to do that. Can I also point out that we are no different from any other airline in the world on this? And certainly all of the airlines operating into Australia. And the vast majority of people that are transported to places like Sri Lanka and other places are travelling on other airlines because we don't fly to those countries. So this is not an issue with Qantas. This is an issue that I think you have with government policy, and I think you have with the way that's set up. This should be an issue addressed that way. And
So it is being addressed that way, but I'd also say Qantas is a listed company and I'm a shareholder of Qantas, and that's why I'm at this AGM addressing this issue today.
And you're quite entitled to it, and we respect. And I think your organisation, we've met independently with your organisation, and I understand your concerns. And I think we've given you the opportunity to express your concerns here, and it's up to the shareholders to make a call. But can I ask, are there any other questions on this topic? Mr. Orrick, yeah.
Introduce Mr. Orrick.
Thank you, Chairman. I thought I heard my name mentioned a little earlier. Normally, a resolution to increase shareholder power might appear beneficial to shareholders, but in our view, we're reluctant to go about changing company constitutions. Our preference is for a public policy consultation along the lines that I think Mr. Joyce mentioned. On whether there should be more or less shareholder rights. And I might add, and I've said this a number of times over the last couple of weeks, that the public policy consultation needs to be led by the government, and the government needs to get into the business of leading it. We can't continue to have a government who are not involved in this sort of policy. And I'll just leave it at that. Thank you.
Thank you. Look, I think we've given that a fair hearing, and the views have been pretty broadly outlined. And as outlined in the notice of meeting, this resolution is a special resolution and requires support from 75% of the votes cast. As chairman of this meeting, I intend to vote all undirected proxies against this resolution. The directors recommend that you vote against this special resolution. So I therefore formally propose the following ordinary resolution: that the company's constitution be amended by inserting a new clause 5.10 as follows. Member resolutions at general meeting.
Chance to speak, which is my right here as a shareholder.
Well, I think, are you going to raise anything new?
Yes, I am.
Okay, well, I'll give you a chance, then we'll put this resolution. I think I've been quite indulgent in giving this particular topic some airtime, but please, raise your question.
Okay, so in March this year, I witnessed firsthand the devastating impact when close friends were transported. Yes, it was a chartered flight, it wasn't Qantas. However, when they were forced on an involuntary flight and their 2-year-old and 9-month-old were separated from them during that flight.
This significantly traumatised the family as well as my rural community. I understand Qantas is also contracted to the Australian government to carry out business of the same nature. So firstly, is the board prepared to rule out the separation of children from their parents? And secondly, do you think participation in this business enhances or detracts from the value of the Qantas brand?
Look, I understand your concern. You were talking about a charter flight. I'm unaware of any circumstance like that occurring with Qantas, and I'd hope we wouldn't see such a traumatic situation. That's
So
all I
is
can
that
say.
a commitment to say that you wouldn't separate children from parents?
We are not. I'm not aware of the government's desire to separate children and transport children separately.
Well,
I'm
that's
unaware.
what they do.
I can't comment on the specific circumstances that you refer to, but I'm just saying that Qantas is unaware of the government's desire to ever do that. So I understand your concern, but that's all I can say about it.
I'll take that as a commitment then. Thank you.
Okay.